Strata Bites, your Strata update, with Frank Higginson from Redchip Strata Law.
If you go back 20 years and look around for the use of the word bullying, you'd probably only find it in the context of the schoolyard. In recent times, you can find it everywhere, primarily in workplaces, absolutely, but it also has an application to strata. So it's a pretty unique link though. So in a workplace, people that are employees have rights under the Fair Work Act with respect to protection from bullying and harassment and all those sort of things. There's no equivalent provisions in strata, but there is a small link with respect to management rights, because bullying can apply to entities or people associated with entities that are constitutionally covered corporations, which is companies. So what can happen in the context of strata, in a building with management rights, where the manager is a company, is that the people involved with that company can access the Fair Work Commission in relation to protection from bullying. So there's been a few decisions lurking around about this. It's a fairly sort of well-known, I suppose, internally, but maybe not externally, issue with strata. One of the problems from a pure legal perspective is that legal costs aren't awarded in there, and what you're actually seeking when you go there is to stop the bullying. There's no awards of damages and those sorts of things. So usually it's not necessarily a financial investment in that sense. But there's been a recent decision which does provide some further clarity for what happens in a management rights context. And this is one where the typical situation where the manager believed they were doing the job, the committee didn't believe they were doing the job, and there's probably a couple of takeaways from me out of that decision. The first one is that having conversations between a body corporate committee and a manager about performance of work is not bullying. Reasonable management action where you're understanding each other's position and raising concerns about performance are appropriate things to do. One of the other ones that came out of this decision for me is in relation to the contact. In a bullying situation in a workplace environment, you can expect all of the conversations to happen in office hours, between 8:30 and 5 o'clock. So if I was getting emails from my boss at 10 o'clock at night, then that absolutely is more than likely going to be inappropriate, unless we happen to both be in the office working on a big matter. In a management rights context, it's different, because committee members are quite often volunteers, which means that they're going to look at committee work after hours. So from a management rights perspective, you've got to be aware that engaging about performance is not necessarily going to be bullying, and that you can expect for things to happen not inside normal business hours. So again, if you need help on any of these things, let us know.